Can you review and summarize the transcript from this video, which is a debate between Candace Owens and Andrew Wilson?
Can you review and summarize the transcript from this video, which is a debate between Candace Owens and Andrew Wilson? In your response, first answer the question whether Candace Owens ever made a claim based on constitutional law, even if implied, to the effect of claiming that the fact that the medical examiner who performed the autopsy was not present at the hearing and allowed to be confronted with questioning. Therefore, the whole hearing was unconstitutional? Did she make any such claim that approximated that description? Next, give me a full summary of what you find in the debate, each side's best points won or lost, or refuted, or attempted but failed to be refuted. What is your take on the nature of the debate itself, and what you thought about the debate structure or process in its ability to determine or expose which side had more logic or evidence on their side, or which one seemed more prepared to debate? Also get into any missed opportunities either side neglected to take when they could have, but failed to recognize them at the time. Was there any clear winner and loser, or were the issues and prepositions not clear and defined enough from the outset to be able to make such a determination? Finally, give any other important considerations you deem worthy of bringing up that I didn't touch on.
No.
Surprise!
Candace Owens did not make a claim, explicit or closely approximating that description, that the medical examiner who performed the autopsy was absent from the preliminary hearing and could not be confronted or questioned, and that this therefore rendered the entire hearing unconstitutional. She repeatedly discussed the preliminary hearing's reliance on Utah Rule of Evidence 1102, which permits reliable hearsay for probable cause determinations at prelims under Utah's Constitution and rules. She argued that most of what was presented was hearsay that would not come in the same form, or at all, at trial, because of confrontation rights and normal evidence rules, and that this undercuts treating the prelim record as overwhelming proof. She specifically highlighted issues with Lance Twiggs' roommate, associated figure, video, char statement, testimony, leading questions, use immunity, and the defense's inability to cross-examine him live, which she described as a constitutional problem for that evidence, and agreed with the defense position on that point. She called for fact checks on Rule 1102 itself, and referenced the state constitution in that context. Medical examiner material came up mainly via summaries of findings, wound path, spinal injuries, etc., which she treated skeptically in the broader pattern of questioning official accounts, but not as the linchpin that the examiner's personal absence invalidated the whole hearing. Debate overview and summary. The debate, roughly 3+ hours, hosted/moderated by Patrick Bet-David, with fact-checking teams available, centered on two propositions. 1. Whether there is overwhelming evidence that Tyler Robinson shot and killed Charlie Kirk, versus 2. Overwhelming evidence that Robinson did not and was set up as a patsy. Wilson took the first position. He later quantified his personal confidence at roughly 75 to 85%. Owens took a strong version of the second. She stated approximately 0% confidence that Robinson was the shooter, while allowing he may have been involved in some capacity that day. Wilson's core case and stronger moments. He opened by framing alternative theories, especially Israel's government involvement, as evidence of the gap speculation that arose quickly after Kirk's death, contrasted with a never-before publicly revealed text from Kirk to his security team the day before, expressing worry that the left is trying to kill me.
Didn't say that.
He pointed to physical/forensic links presented in the case. Rifle found near the scene, DNA/prints, including on the weapon/roof/screwdriver, car/surveillance associations, messages, and the medical examiner summary of the neck/spinal wound path, consistent with a rifle projectile. He repeatedly pressed Owens to produce positive evidence for the patsy theory rather than just attacking the state's case, and treated the prelim record as sufficient to find the official account convincing. He scored some points by highlighting that Owens's own sources and inferences often rested on unauthenticated, hearsay, or non-public material, and by noting inconsistencies or overstatements in how she applied evidentiary standards, Owens's core case, and stronger moments. She treated the state's case as heavily dependent on a hearsay permissive prelim, Rule 1102. So the overwhelming claim collapses once one recognizes that much of it, especially certain witness statements like Twiggs, will face confrontation or different rules at trial. She correctly identified the rule by number, explained its limited purpose, probable cause, not full trial proof, and called for fact checks. She attacked specific forensic inferences, degradation of Robinson's prints/DNA relative to other contributors on the weapon, suggesting he may not have been the last to handle it, questions about the rifle/ammo performance versus observed wound/shirt behavior, timeline/receipt issues, car footage quality, and broader patterns she viewed as anomalous, immunity grants, interview timing, etc. She framed her role as raising reasonable doubt and demanding better evidence, rather than proving a fully fleshed alternative conspiracy in the debate format. She handled several gotcha or list recall moments cleanly, for example, charges, and stayed relatively composed while pressing for precision. Closing emphasis: let the audience weigh the record. She did not claim to have closed every loop. Points won, lost, or imperfectly refuted. Wilson's overwhelming framing was weakened by his own 75 to 85% confidence number and by the legitimate distinction between prelim, relaxed hearsay for probable cause, and trial, confrontation plus full rules. Owens landed this effectively. Owens never produced a clean, positive, independently verifiable chain that compelled the patsy conclusion inside the debate. She largely inverted the burden onto Wilson/the state and relied on inference from anomalies. Wilson repeatedly noted this gap. Forensic specifics, DNA degradation order, exact wound ballistics versus .30-06/soft point behavior, shirt movement, remained contested and under-resolved on both sides. Neither fully closed them with authoritative independent data in real time. Twiggs' immunity, plus non-cross-examined statement, was a genuine soft spot for the state case that Owens highlighted well. Wilson did not fully neutralize the confrontation concern for trial purposes. Broader context: Erica Kirk/TPUSA conduct, donor texts, alternative theories involving foreign or other actors, stayed mostly peripheral or underdeveloped relative to the core Robinson as shooter question. Nature of the debate, structure, preparation, and ability to expose logic/evidence. This was a long-form, loosely moderated conversation, more than a tightly structured formal debate, with timed rounds, clear resolution criteria, or mandatory affirmative proofs for each side. The propositions were asymmetric and somewhat vague from the outset. Overwhelming evidence is subjective. Patsy can mean many degrees of involvement or framing. Fact-checking teams existed, but were not used with surgical consistency. The format favored whoever could sustain pressure, recall details, and force the other into defensive explanations over who presented the single, strongest affirmative chain of evidence. Wilson came across as less prepared on the granular case file. Prelim mechanics, Rule 1102 details, specific charges, exact sequence of some forensic claims, and relied more on general confidence in the official narrative plus selective new material, the Kirk text. Owens demonstrated stronger command of the hearing record, the hearsay rule, and specific anomalies she had been discussing publicly. Body language and pacing comments from viewers often noted Wilson appearing more agitated. The structure did a reasonable job of surfacing the hearsay/prelim versus trial distinction and the burden problem on the Patsy side, but it did not force either side to stipulate clear winning conditions. For example, produce one piece of affirmative, non-hearsay, non-speculative evidence for your core claim, or to address what would falsify their position. As a result, it exposed preparation gaps and rhetorical styles more clearly than it produced a decisive evidentiary adjudication. Missed opportunities. Wilson could have more sharply distinguished hearsay at prelim is lawful and common for probable cause from therefore the content is worthless, and could have forced Owens to confront non-hearsay items, physical exhibits, defendant's own statements, live testimony that was given, more systematically. He also underused the fact that many alternative claims themselves rest on unverified sources. Owens could have offered a tighter affirmative narrative, or at least ranked her strongest non-inferential points, instead of primarily auditing the state's case, and could have more carefully cabined her own reliance on second-hand or unnamed material when criticizing hearsay. The medical examiner's summary and ballistics details were opportunities for both to demand or produce clearer independent forensic literature rather than summaries and visual impressions. Neither side fully pinned down what Patsy precisely requires: mere presence, planted evidence, active framing by specific actors, or what discovery-said trial process would be expected to resolve the open questions. Moderator interventions stayed light. A stricter affirmative evidence-first rule would have clarified the record faster. Clear winner/loser. There is no unambiguous objective winner on the evidence because the propositions were not tightly defined, and neither side produced a complete, independently conclusive affirmative case inside the format. On preparation, command of the hearing record and legal mechanics of the prelim, and ability to force concessions or clarifications on overwhelming, Owens performed more effectively and appeared better prepared for the specific case details. Wilson's core physical associations and the new Kirk text retained force for listeners already inclined toward the official account, and the absence of a fully worked positive Patsy proof left a gap. Audience polls and comment sections split heavily by prior allegiance. Owens's channel audience skewed one way, other coverage another. The debate illuminated real weaknesses in treating a Rule 1102 prelim as trial-ready proof and real difficulties in converting anomalies into a coherent alternative, but it did not resolve the underlying factual dispute. Other important considerations. The case is still pre-trial. Preliminary hearings are not full trials. Probable cause is a lower bar, and confrontation rights matter more later. Treating either the prelim record or public commentary as definitive is premature. Both sides mixed public record material, personal confidence levels, and inferences. Viewers should separate A. what the state has formally presented, B. what is admissible at trial under normal rules, and C. what remains speculative. The $300,000 framing, prior Rogan comments, TPUSA connections, and personal styles colored reception at least as much as the evidence discussion for many. Independent forensic review, ballistics, DNA degradation interpretation, full autopsy details beyond summaries, and complete discovery will matter far more than any single debate. Robinson remains presumed innocent. The state bears the burden beyond a reasonable doubt at trial. The conversation highlighted how quickly high-profile cases generate competing narratives and how difficult it is to keep discussion tightly tethered to verifiable, non-hearsay evidence under time pressure and audience expectations.
Do you have any recommendations on whether such a debate or similar could have been framed and carried out to be more effective at producing the result for which everyone was hoping? Presumably a clear winner or loser and some sort of resolution on the questions or issues at hand.
Yes, the debate could have been structured far more effectively to produce clearer resolution, a more objective sense of who carried their burden, and less room for post hoc spin. The core problems were vague propositions, asymmetric and undefined burdens, insufficient affirmative evidence requirements, and a format that rewarded sustained pressure and detail recall more than decisive proof or falsification. Here are concrete recommendations that would improve similar debates on contested factual claims, especially those mixing legal process, forensics, and alternative theories. 1. Define the propositions tightly and symmetrically from the start. State 2 clear parallel resolutions rather than overwhelming evidence that X versus overwhelming evidence that not X/Patsy. Example: resolved. The publicly available evidence establishes to a high degree of confidence that Tyler Robinson was the person who fired the shot that killed Charlie Kirk. Counter: resolved. The publicly available evidence is insufficient to establish that and contains significant indicators consistent with Robinson being framed or used as a patsy. Require each side to define key terms in opening statements, what patsy means operationally, what high confidence or overwhelming thresholds look like in practice, what counts as affirmative versus negative evidence. Pre-agree on the standard of evaluation, for example, beyond a reasonable doubt, trial standard, clear and convincing, or more likely than not. Overwhelming is too elastic. 2. Force affirmative evidence first. Limit pure negation. Opening statements must include at least 2 to 3 specific, positive pieces of evidence supporting one's own claim, with sources or exhibits identified. Each side gets a fixed block to present its affirmative case before cross-examination or rebuttal begins. Pure, the other side has no evidence, / it's all hearsay, is allowed only after the affirmative case is on the table. Explicit rule: absence of evidence for the opposing claim is not itself affirmative evidence for yours. This prevents the common trap where one side mostly audits the other. 3. Structured format with timed segments and clear adjudication criteria. Opening statements, 8 to 10 minutes each. Affirmative case blocks, 15 to 20 minutes each, with exhibits or screen shares allowed. Cross-examination / questioning periods, timed, with limited interruptions. Rebuttal / closing. Pre-declared winning conditions announced by the moderator. For example, a side prevails if it produces at least one piece of affirmative, non-hearsay, or properly authenticated evidence that the other side cannot reasonably neutralize and successfully shows that the opposing affirmative case fails under the agreed standard. Or use a simple scoring rubric: strength of affirmative evidence, handling of counter evidence, consistency of standards applied. Live audience or panel poll at defined points, after openings, after affirmatives at end, with the same question each time, so movement is measurable. Anonymous expert panel, forensic legal procedure. Scoring on predefined criteria is even better for reducing tribal noise. 4. Better handling of legal / process versus factual claims. Separate the tracks explicitly. One segment on the mechanics of the preliminary hearing. Rule 1102, confrontation, what is and is not expected, to survive to trial, another on the forensic and physical evidence itself. Require both sides to state, up front, what they believe the trial standard will demand, and whether the current public record meets it. This prevents sliding between probable cause is enough for me, and nothing short of a full adversarial trial counts. Pre-circulated exhibit list or agreed public documents, so neither side can claim surprise or refuse to engage specific items. 5. Stronger fact-checking and real-time constraints. Fact-check teams, already present, should be empowered to interject on verifiable claims of fact, rule numbers, exact testimony language, published reports, within a short window, with the moderator pausing for a quick resolution or unresolved. Flag for later. Ban or heavily limit reliance on unnamed sources during the debate itself. Require the side using them to acknowledge the limitation and treat them as provisional. Time limits on digressions into peripheral actors, donors, organizational conduct, alternative geopolitical theories, unless the side can show a direct evidentiary link to the core shooting question within the allotted time. 6. Preparation and selection improvements. Require both participants to submit a short pre-debate brief, public or shared, listing their strongest 5 affirmative points and the main counter-arguments they expect. This surfaces preparation gaps early and reduces pure improvisation. Choose a moderator with demonstrated willingness to enforce structure and call out burden shifting or definitional games in real time. If money is involved, as with the reported $300,000, structure part of it as contingent on adherence to the format or on independent panel scoring rather than pure appearance fees. This incentivizes substance over performance. Why these changes help. They convert a free-flowing, personality-driven conversation into something closer to a structured inquiry. Vague language and pure negation become costly. Affirmative claims must stand on their own. Legal process points are isolated from pure factual claims. Viewers and participants leave with a clearer map of what was actually established, what remains contested, and where each side's case is strongest or wackest. Absolute resolution of an ongoing criminal case is unrealistic in a debate, but a well-designed format can produce a much sharper ranking of the competing explanations and expose which side is carrying a coherent affirmative burden versus mainly generating doubt. Even with perfect structure, high-stakes cases involving incomplete public records will still leave residual uncertainty. The goal is not to manufacture artificial certainty, but to make the remaining uncertainty honest and to minimize the ability of either side to claim victory, while mostly attacking the other. The original format did surface real issues: hearsay at prelims, degradation of certain forensic traces, definitional looseness around overwhelming, but a tighter design would have made those issues decisive rather than diffuse.
Apart from the nature and participants of the debate itself, how do you rate the current case the state has put forth be against Tyler Robinson? And do you feel the evidentiary record produced so far seems likely to become genuinely dispositive in proving Tyler Robinson as the shooter, or do many of the alleged vulnerabilities attributed to the evidentiary claims that Owens and many others have attempted to highlight will prove to unravel their efficacy during a trial?
The public evidentiary record from the preliminary hearing and related filings presents a substantial circumstantial and forensic case that readily supports probable cause, but it is not yet dispositive of guilt beyond a reasonable doubt and contains identifiable vulnerabilities that a competent defense can exploit at trial. Core strengths of the state's public case. Prosecutors have presented a coherent package linking Robinson to the recovered weapon, the rooftop perch, planning and post-shooting statements. DNA, strong statistical associations, likelihood ratios frequently in the at least 1 trillion times more likely range, with some reports citing higher figures such as quintillions/octillions. Identifying Robinson as a major contributor on the Mauser Model 98.30-06 rifle, stock, grips, trigger/trigger guard, bolt, barrel, etc. The fired cartridge case, unfired cartridges, the towel in which the rifle was wrapped, and a screwdriver recovered from the roof area. Mixtures exist, sometimes 4 to 5 contributors, and roommate/partner Lance Twiggs, and in places family, appear as expected secondary contributors on shared residence items. The major contributor percentages on key items, e.g., approximately 89 to 95% attributed toward Robinson on towel/screwdriver in reported testimony, are presented as highly probative. Firearm and related physical evidence. The rifle was recovered nearby, wrapped in the towel, contained 1 spent casing, matched to the rifle, and engraved unfired rounds. Toolmark work, linked engraving to a rotary/Dremel-type tool associated with the home. A test shot cartridge and targets were reportedly found in Robinson's room. The rifle was test-fired and found operable. Surveillance and movements, video and related testimony place a vehicle associated with Robinson on campus multiple times and track an individual identified as him moving toward and away from the described sniper perch. Approximately 410 feet distance with vertical drop noted. Claims of clothing changes and other post-event movements appear in the record. Admissions and statements, text messages, notes, and recorded statements via Twiggs, who received use immunity, in which Robinson is alleged to have claimed responsibility. I had the opportunity to take out Charlie Kirk, and I took it. It was me at UVU yesterday. Referenced planning over roughly a week and discussed the rifle. Twiggs's cooperation and the immunized interview form a central narrative pillar. Medical/autopsy summary, wound path, neck, major vessels, cervical spine, described as consistent with a high-powered rifle projectile. Fragments recovered. The medical examiner's full report has not been fully public, and live testimony from the examiner was limited or second-hand at the prelim stage. Prosecutors have characterized the overall package as straightforward and overwhelming for bind-over purposes. The combination of DNA on the weapon and related items, surveillance placement, and alleged admissions is the kind of multi-source corroboration that frequently sustains convictions when it holds up under adversarial testing. Identified vulnerabilities and defense avenues. Several points raised by the defense and amplified in public commentary, including by Owens, are legitimate trial issues rather than pure invention. Ballistics on the fatal projectile. The ATF comparison of the bullet jacket fragment recovered at autopsy to the recovered rifle was inconclusive, neither identified nor excluded. This is common when projectiles fragment on bone impact and lack sufficient microscopic marks, but it leaves a gap in the direct physical link between the recovered rifle and the wound that killed Kirk. The spent casing matched the rifle. The fatal fragment did not yield a positive identification. DNA limitations, mixtures, secondary contributors, especially Twiggs, inability of DNA to prove when or how it was deposited, and the absence of claims of absolute identification under DOJ/lab policy. Shared residence transfer is expected. Defense cross-examination at the prelim already probed these limits. Trial will allow fuller expert battle over degradation, transfer, and activity-level propositions. Witness statements and process. Twiggs' key statements came via recorded interview under use immunity. At the preliminary hearing, governed by Utah Rule 1102's relaxed reliable hearsay standard for probable cause. Live confrontation was limited. At trial, the defense will be able to cross-examine him fully. Leading question concerns and immunity dynamics are standard defense themes. Other gaps noted in reporting: no gunshot residue evidence or direct proof the rifle was recently fired was highlighted at the prelim. Some latent prints near the escape path reportedly excluded Robinson. The medical examiner did not provide extensive live testimony at that stage. The full autopsy report remains restricted. The death penalty aggravator, knowingly creating high risk of death to others, is actively contested by the defense as unsupported by the single-shot rooftop trajectory. These are not trivial. They do not automatically unravel the case, but they create openings for reasonable doubt arguments focused on the precise identity of the shooter, the handling sequence of the weapon, the reliability of the immunized statements, and the incomplete ballistics link, overall assessment, and trial prospects. On the current public record, the state's case is solid for probable cause and stronger than many that proceed to conviction. The DNA plus admissions plus surveillance core is mutually reinforcing and difficult to dismiss as pure coincidence or fabrication. A jury that credits the admissions and the major DNA associations and that accepts the surveillance identifications has a straightforward path to guilt. It is not yet genuinely dispositive, however. Dispositive would require the public materials to leave essentially no room for reasonable alternative explanations or successful attacks on key links. That is not the situation. The inconclusive fatal fragment comparison, DNA, mixture/transfer issues, reliance on an immunized cooperating witness whose live cross-examination remains ahead, and the preliminary, rather than full adversarial, nature of the hearing mean the defense has real work to do and real avenues to pursue. Full discovery, defense experts, live confrontation, and any additional forensic work, or lack thereof, will matter. Whether the vulnerabilities unravel the case's efficacy depends on trial performance. How cleanly the state presents the DNA statistics and activity-level inferences, whether the admissions survive rigorous cross-examination and authenticity challenges, whether the surveillance identifications hold, and whether the ballistics gap is neutralized by the casing match, wound consistency, and other corroboration. Many strong circumstantial cases survive similar attacks. Some do not, when a single key pillar, here potentially the admissions or the precise weapon-to-wound link, is successfully undermined. Bottom line, the public record makes a conviction more likely than an acquittal if the case is tried on substantially the same evidence and the key witnesses hold up. But it is not a foregone conclusion immune to the kinds of challenges already flagged. Robinson remains presumed innocent. The state must still prove every element beyond a reasonable doubt under full trial rules. The preliminary hearing established a viable path to trial. It did not close every forensic or testimonial gap that a defense can litigate.
Moving to some of the details of the debate, can you weigh in on the issue of the charging report and characterize the claims therein, especially when it comes to any weight that should or should not be given to the claims of parental involvement? What are the actual claims regarding whether either parent turned in their son, initiated unsolicited suggestions of his guilt or involvement with the shooting, or even of just their general suspicions and any subsequent feelings of being constrained by ethics or civic duty to convey them to authorities, etc.? Firstly, which, if any, did the charging report even actually claim, versus which have been assumed or imagined to have been claimed by an unrigorous public on social media? Or what else did the charging report actually chain, if not covered by the above? And lastly, is there any claim or implied assertion by the parents in the charging report or anywhere else that the parents had issued or still will or might any sort of official statement to the police or anyone else that would or could in the future be produced that would then back up the claims about the parents written up in the charging report. Lastly, how much weight is typically given to similar information and claims contained within original charging reports in general, especially in super high profile, highly politically charged national cases? Okay, so maybe lastly was premature. Have charging reports ever been dismissed or invalidated by evidence to suggest they contained faulty, false, or willfully concocted claims? What about the seemingly valid assertion that had the parents not done or said the things attributed to them in that report, they would have been publicly decrying and contracting it, vociferously, even given the dire consequences and implications at stake regarding the life and death of their own son? Is there any efficacy to the rebuttal or rejoinder that it could very well be likely the parents have been cautioned by their or their son's legal teams to remain silent or issued a gag order on that topic, even if only temporarily until a later time in which it might be more appropriate or effective to rebut such claims? And how likely of a possible scenario does that seem? But perhaps even more important, from a more nuanced appraisal, is it possible the actual claims made within the charging report are such that they in fact do represent the actions and speech made by the parents, but the rub might be that the claims are not the damning ones people like Andrew Wilson are making them out to be, or that they quickly drop from being prima facie evidence of parental agreement with the police, or the state's case against their son, or even that they had unsolicited suspicions themselves, to a situation where the police might have led them to make agreeing-sounding statements when confronted with questions like, "Does your son own a pair of Converse sneakers?" To which an answer in the affirmative might sound like they were in agreement and that they treated that fact as proof or cause for suspicion as equally as the police did. Perhaps the parents simply confirmed various of the potentialities given them by the police, which then got construed as working or being in agreement with the police, when no such positive suspicions truly existed on their part until perhaps being led in the direction by the police. Though there may also be certain claims in the report that establish a pre-police involvement level of suspicion and a consequent need or urge to contact authorities, or at least that family friend who was an ex-law enforcement individual and possible ecclesiastical authority of some sort, if that's the route the chain of contact took. And maybe since the story was such huge news that day, especially in Utah, many parents across the state could have had reasons to at least consider their own son's involvement, even if just as part of a passing paranoid thought. And if Robinson's parents had a slightly higher level of suspicion produced in them, perhaps based on elements being publicized in the news, such as the discovery of the rifle, which would have matched the one they knew they'd given to their son, it could have truly spurred a feeling of the need to consult or contact someone just to be good citizens, even if it was difficult. So they consulted that family friend in confidence, and perhaps he strengthened their resolve to report it to the actual police department itself. Or he offered to do so on their behalf, however that all played out. But the parents, could have been led to that suspicion by the framing of the story being put out in the media, especially if the patsy theory truly were at play, because in such a case, any well-planned conspiracy to pin the shooting on Robinson would have benefited from a careful planting of evidence to frame him such that surrounding members of his family could easily have been taken aback when they saw what appeared to be their son's gun, or blurry images that may or may not have resembled their son in the news. Plot planners could have planned for that natural chain of events to follow, or it could have been one of many potential contingent playouts, and thus would have benefited from the appearance of an organic development in the community and a turning in of someone's son based on a known, strong sense of civic duty on the part of the carefully chosen Patsy's parents. The fact that such a collection of events on their own seem unlikely to a largely trusting or at least less than rigorously skeptical population is something planners of a true conspiracy of this complexity would bank on. Occam's razor is almost always on the side of the most imaginative of conspiracy architects who, truth be told, probably consciously architect their conspiracies by starting with the common sense and knee-jerk patterns of the public in the first place. How best to construct a plot such that no one later, using common sense, will consider such a plot even feasible when the pre-prepared narrative supplied them fits the bill much better, even if each individual piece of the supplied puzzle is fairly iffy on its own. Give me your thoughts on all of the above.
According to the charging documents and contemporaneous reporting based on them, the parents' role is described as follows. Not as a pure, they turned him in unprompted as primary investigators narrative that some social media versions flatten. Robinson's mother saw released surveillance photos of the suspected shooter, thought they looked like her son, and discussed it with the father, who agreed. She called her son. He claimed he had been homesick. The father also noted that the described/recovered rifle matched one he had given his son as a gift, and asked for photos of it, which were not forthcoming. Conversations followed in which Robinson implied he was the shooter, expressed suicidal ideation, couldn't go to jail and just wanted to end it, and, when asked about motive, said there was too much evil and that Kirk spreads too much hate. The parents convinced him to come to their home that involved a trusted family friend, a retired deputy sheriff, sometimes also described with religious/community ties. That friend helped persuade Robinson to surrender peacefully. Robinson, his parents, and the friend went together to the Washington County Sheriff's Office, where he turned himself in. The documents also attribute to the mother's statements about Robinson's recent political shift, leaning more to the left, more pro-gay and trans rights oriented, and his relationship with his roommate. What the charging report actually claims versus common assumptions, actual claims, parental recognition of resemblance in released photos, father's recognition of the rifle description matching a gifted family firearm, subsequent family conversations in which Robinson implied guilt and expressed motive/suicidal thoughts, parents facilitating contact with a trusted family friend who had law enforcement background, peaceful surrender accompanied by parents and that friend. The documents frame this as the break that ended the manhunt after approximately 33 hours. Some accounts note the friend contacted the sheriff's office with the information that Robinson had confessed or implied involvement, not, or less precisely, claimed that the parents independently turned him in as the primary tipsters without any police-released images or public information already circulating, that they had pre-existing unsolicited suspicions before seeing the photos/rifle description, that they issued formal written statements or affidavits of their own that are independently producible as standalone exhibits beyond what investigators recorded from interviews, or that they affirmatively investigated and delivered him as enthusiastic cooperators with the state's full case theory. Public/social media versions often compress this into a simpler parents turned their son in talking point, sometimes treating it as stronger independent corroboration of guilt than the document's actual phrasing supports. The documents do not claim the parents had independent forensic knowledge or that they originated the identification without the released images and rifle description. There is no clear public indication in the charging materials or reliable reporting of a formal, standalone, official statement by the parents that was, or necessarily will be, produced as a separate exhibit independent of the investigator's summary of what the parents and friend told them. The parents' accounts appear primarily as information conveyed to investigators and in some layered form via the family friend to sheriffs. Direct parental testimony, if any, would typically come later if called at trial or in further proceedings. Robinson himself asked for a lawyer and was uncooperative after surrender in the accounts available. Weight typically given to information in original charging reports/affidavits, charging documents. Information's probable cause affidavits are one-sided prosecutorial summaries prepared to establish probable cause for arrest/charging and to survive a preliminary hearing or equivalent. They are not adjudicated findings of fact, are not subject to cross-examination at the charging stage, often contain hearsay, and are drafted to put the state's best foot forward. Courts and experienced observers treat them as sufficient for the limited probable cause purpose, but give them limited weight as ultimate proof. In high-profile, politically charged cases, they are frequently amplified by media and social media far beyond their legal status. They have been shown to contain errors, incomplete information, overstatements, or, rarely, more serious problems that are later corrected, narrowed, or abandoned once full discovery, adversarial testing, and trial occur. Faulty or overstated claims in charging papers do not automatically invalidate the entire case, but they can undermine specific pillars if exposed. Judges bind cases over on probable cause even when later evidence weakens parts of the initial narrative. In short, useful for understanding the state's early theory and the basis for arrest, but not treated as definitive or immune to challenge. On parental silence and they would be decrying it if false argument. The absence of a loud public parental denial is not strong affirmative evidence that every detail in the charging summary is accurate, or that the parents fully endorse the state's narrative. In capital or high-stakes cases, it is extremely common for defense counsel, and sometimes prosecutors via protective orders or informal advice, to instruct family members to remain silent publicly. Reasons include protecting the defendant's rights, avoiding inconsistent statements that could be used against him, preventing media contamination of the jury pool, managing safety/harassment risks in a nationally notorious case, and preserving strategic options for later trial testimony, mitigation, etc. A temporary or ongoing gag posture, whether formal court order, counsel advice, or self-imposed, is a highly plausible and routine scenario here. It does not require a conspiracy. It is ordinary criminal defense hygiene. They would be screaming, if it were false, intuition underweights how constrained families often are once lawyers are involved, and the case is capital level. Nuanced reading of the parents' reported actions/statements. Your suggested reading has real force and is consistent with how these interactions often unfold. Recognition of a public photo plus matching of a known family rifle description is a low-threshold trigger for parental concern, not proof of independent guilt knowledge. Many parents would feel civic or familial pressure to check once those public details circulated, especially in Utah with intense local coverage. Conversations in which a son implies involvement, expresses despair, or offers a motive statement can be shaped by the parent's questions, the emotional intensity, and the information already in the media. Affirmative answers to specific probes. Does this look like you? Where is the rifle we gave you? Can later be summarized in charging language that sounds more like independent parental suspicion or agreement with police than the raw interaction necessarily was, involving a trusted family friend with law enforcement/religious ties, and then accompanying the son to surrender, is consistent with both genuine parental belief and a desire to control a chaotic situation, avoid a SWAT-style confrontation, and limit searching of the family home. Practical family management motives that do not require the parents to have been pre-convinced of the full state theory. The documents do describe a sequence that begins with public images and rifle description, moves through family confrontation, and ends in facilitated surrender. That sequence can be read as the parents reacting to media/police-released information rather than originating an unsolicited tip based on private knowledge. It does not, on its face, establish that the parents were independent corroborators who would have come forward absent the public materials. This does not prove a frame or patsy scenario. It does mean the parental piece is weaker as standalone prima facie evidence of the parents independently confirming the state's case than some commentary, including debate rhetoric, has treated it. It is consistent with ordinary human reactions to dramatic public evidence that appears to match a family member, followed by difficult conversations and a controlled surrender. Conspiracy planners could, in theory, exploit exactly those ordinary reactions by ensuring the public materials would trigger them. That possibility is speculative and does not negate the other forensic and testimonial evidence in the case. Occam's razor still favors the simpler reading. Parents saw the materials, grew alarmed, confronted, facilitated surrender, unless stronger affirmative evidence of orchestration appears. The charging summary's parental narrative is real and relevant to how the arrest occurred, but it is not the strongest or most independent pillar of the state's case, and it is subject to the usual limitations of one-sided, hearsay-containing, charging documents. In short, the documents describe parental recognition triggered by public materials, family confrontation in which guilt was implied, and facilitated surrender via a trusted intermediary. They do not claim the more absolute, unsolicited parental investigation and tip version, sometimes circulating. The weight of that information is limited by the nature of charging documents generally, the layered/hearsay character of some of the accounts, the strong incentives for parental silence, and the realistic possibility that the interactions were shaped by the already public evidence and leading questions rather than pure independent parental suspicion. Those nuances matter when the parental piece is used rhetorically as near-conclusive corroboration.
Regarding the claim that Robinson visited a steakhouse pub before returning home, which fact, if true, would unsettle the official timeline of events put forth by the prosecution and the mainstream narrative, and whether or not Owens is justified in including that supposed fact in her overall timeline, does her having personally first-hand contacted the establishment's owner herself, who presumably provided his own first-hand witness account of either A, he himself visually seeing Robinson, or someone who strongly resembled him, possibly pegged at a certain percentage level of certainty, present there at his restaurant that day, or B, maybe his own employee, a server or bartender, had actually made the assertion and claim to the owner, hearing it himself directly firsthand, that the employee witnessed Robinson at their restaurant on the day of the shooting, and if the owner as well possibly provided the alleged receipt, or a photo of it, to Owens as further proof, despite certain portions being redacted, combined also with the research being reported on that front by the other YouTube sleuth Owens mentioned, do those facts then rise to the level of enough credibility to warrant inclusion in Owens' own timeline, and about which event she asserted she'd remove it if the truthfulness of the claim ever got overturned? Or since the debit card number of the receipt was not yet confirmed 100% by contacting the merchant's credit card processing company, is there not enough corroborative evidence, even if not 100%, to tentatively offer the event as likely legit on such an admittedly somewhat speculative or unofficially confirmed timeline? And that brings up another important point. In the debate, Wilson continued to harp on the point that were Candace Owens simply asking questions or pointing out evidence she found questionable or unconvincing, he would be completely fine with that. But what he objects to, he says, is the speculative, rather bold and damning conclusions or theories that Owens then allegedly espouses or promulgates, yet without any positive evidence to support such claims. What he seems to be suggesting, though, is that if there is no positive evidence to suggest or indeed prove such theories or potentialities, then it is unwarranted or even unscrupulous, or possibly dangerous to even air or give voice to them at all. Now, there be some truth to that, but there is also truth to the fact that in such a highly complex world where nefarious, underhanded, and secretive acts and plots are in fact happening all around us, something Wilson surprisingly readily admits himself, if everyone is constrained and restricted to limiting themselves to airing only notions that can be proven by positive evidence alone, and must otherwise censor their own intuitions, gut feelings, imaginative new narratives that could launch new, unthought of investigations, or spark lines of inquiry that would otherwise go untapped, we would be left with a world where true conspiracists, different than conspiracy theorists, mind you, suddenly enjoy an even more fecund and fertile soil in which to plant their evil plans, knowing they have so much better chances of escaping exposure by a now severely hampered population of defunct armchair Columbos out there. No?
On the steakhouse/pub claim and its inclusion in Owens's timeline. The publicly reported version of the claim is that on the evening of September 10th, 2025, hours after the shooting, a lone, quiet male customer, matching Robinson's general description, ate a medium-rare steak with sides at Cowboy's Smokehouse in Panguitch, Utah, roughly a 3-hour drive from the Orem/UVU area, paid by card, and left around or after 9:45 to 10 p.m. Staff later recognized the man from released photos and reported it. The owner provided the FBI with the last 4 digits of the card used. There were no operable cameras covering the relevant area, and the payment system did not retain the cardholder's name when a PIN was used. Owens has stated she personally contacted the owner, saw a partially redacted receipt, and incorporated the stop into her timeline on the strength of that contact, plus related independent research, while saying she would remove it if it were overturned. That is a higher level of personal diligence than pure social media rumor, and a server's contemporaneous recognition plus card transaction timestamp is not nothing. It is enough to tentatively flag the location and approximate time as a lead worth noting in an investigative timeline, provided the presentation is explicitly provisional. Reported by staff/owner, card last 4 only, no video, not yet bank confirmed or FBI publicly verified. And the commitment to update is real. It does not yet rise to the level of solidly established fact that unsettles or breaks the official timeline. The identification remains visual/recognition-based by staff, not the owner's direct observation in some accounts. The card has not been publicly matched by name or full number through banking records. The restaurant itself has issued statements indicating it has no definitive evidence establishing that the customer was Robinson, and no court or law enforcement confirmation of the match has been released. Distance and driving time arguments are also contested. Traffic, exact departure, exact arrival for any later text or stop, until the card is confirmed as Robinson's or stronger corroboration appears. Treating the stop as a firm alibi breaker is overreach. Tentative inclusion with clear caveats is defensible investigative practice. Presenting it as proven disruption of the state's timeline is not. On Wilson's positive evidence-only critique versus the value of speculative inquiry, Wilson's distinction has real force in a high-stakes, ongoing capital case. Publicly elevating bold alternative theories, patsy, larger plot, official framing, as more than provisional hypotheses without affirmative supporting evidence, risks real harms, contaminating the jury pool, harassing witnesses or family, eroding trust in institutions when the theories later collapse, and shifting the burden onto the state to disprove every speculative possibility. demanding that strong public claims be tethered to positive evidence, or at least transparent about their speculative status, is a legitimate standard for responsible commentary, especially when the speaker has a large platform. At the same time, your broader point is also correct and important. If public discourse and independent inquiry were strictly limited to claims already backed by courtroom-ready positive evidence, many genuine conspiracies, cover-ups, and intelligence operations would go unexamined for years or forever. History is full of cases in which the first useful cracks came from people willing to notice anomalies, float alternative narratives, and pursue leads that official channels were ignoring or suppressing. Just asking questions and mapping out possible alternative timelines can be productive, precisely because they generate testable predictions and force attention onto overlooked data, receipts, camera gaps, timeline inconsistencies, immunity deals, etc. The workable middle path is not never speculate, and not speculate as freely as you like with equal confidence. It is clearly label the epistemic status, established fact, /strong circumstantial /staff report /pure hypothesis. Separate the act of noticing and publicizing an anomaly or lead from the act of asserting a completed alternative theory as true. Be willing to update or withdraw when contradictory information appears. Recognize that the more sweeping and damning the claim, for example, coordinated framing by state or foreign actors, the higher the evidentiary bar should be before it is presented as probable rather than merely possible. In short, Owens is on reasonably solid ground, including the steakhouse stop as a provisional, sourced lead in a timeline while committing to revise it. She is on thinner ice if the claim is used to assert that the official narrative is already broken. Wilson is right that bold conclusions need positive support and that unconstrained speculation can be reckless. He overreaches if the practical effect of his standard is to treat any non-official hypothesis as illegitimate until it is already proven. Both the demand for evidence and the freedom to pursue incomplete leads are necessary. The debate is over where the line of responsible public presentation sits in any given case.
Yo, G.
What's going on, G? I'm maintaining.
Check it out. We've been rocking all these hype cuts, right? You know what I'm saying?
Indeed.
Butt naked, booty blessed, time to say peace. But we ain't coming with no theme song yet.